Good afternoon. I will immediately turn to the activities in the courtrooms of the tribunal. Yesterday, a status conference was held in the case of Vojislav Šešelj, during which the accused informed the chamber that he did not intend on calling defense witnesses, but that he would present closing arguments for which he requested 10 days. The chamber is now going to rule on the future course of the proceedings, and as was said in the courtroom, they will meet today in camera. The chamber also briefly discussed yesterday the health situation of the accused and said that according to the report of the two medical experts who had examined Šešelj, it had no particular reason to be concerned about his health. He is yet to be examined by a cardiologist because he refused to be examined by the one that was designated by the registrar. The next administrative hearing will be held in October at a day and time to be confirmed. In the retrial of Ramos Haradinaj and others, the chamber this morning decided to admit transcripts of the Šefket Kabashi testimony which he gave in the Limaj and other case. Kabashi, a former member of the KLA and key prosecution witness in the case, is facing contempt of court charges for refusing or failing to answer questions while testifying before the trial chamber in 2007. His further initial appearance for the contempt will be held this Friday at 12 o'clock in courtroom 3, during which he will be given an opportunity to enter a plea to the charges he faces. In the trial of Javca Stanšić and Franki Simatović, the trial chamber is currently hearing the testimony of a protected witness who is testifying in closed session. The chamber has partially granted Stanšić's request for postponement of proceedings, and the trial will adjourn on 5th of September for a total of 4 weeks. In the case of Zdravko Tolimir, expert witness Richard Butler, a former military analyst in the office of the prosecutor of the ISTY, who is testifying about the Army of Republika Srpska's organization and structure during its operation in Srebrenica. And in the trial of Radovan Karadžić, the trial chamber will this afternoon hear the testimony of Dževad Gušić, former president of the Party of Democratic Action in Bratunac, who is testifying about the events that took place there during the indictment period. This afternoon, Goran Hadžić's further initial appearance will be held at 3 o'clock in courtroom 3. Yesterday, the pre-trial chamber granted the registrar's request for an extension of time until Friday, 23rd of September, to assign counsel to the accused, because the registry needs time to assess the qualification of the counsel of the accused's choice, who is not currently on the Rule 45 list of qualified lawyers, which is being maintained by the registry. Mr. Zoran Živanović will remain duty counsel until the lead defense counsel has been appointed by the registrar. And tomorrow afternoon, a status conference will be held in the case of Ratko Mladić at 2:30 in courtroom 3. Please note also that next week the tribunal will be closed on Tuesday for Eid ul-Fitr. And finally, I would like to remind you that today is the first interactive press briefing, which means that the media and the members of the public who wish to pose questions, who are not able to attend this press briefing, are able to send those questions in writing and have them answered following our Q&A sessions.
No statement from the Office of the Prosecutor.
Thank you. Questions from The Hague?
I don't know if I understood Šešelj's representations correctly. Does he want to present closing arguments now in view of the normal presentation of a defense case? Or will the normal course of action be followed by which the OTP would, of course, first make its closing arguments and then Šešelj would follow with the 10 days he requested, if granted by the judges?
Obviously, it depends on what the future course of the proceedings are, and a lot will depend on what the trial chamber decides after they meet today, and if they have further meetings, I expect there will be either a written decision issued or possibly even an oral decision at the next administrative hearing. You could have heard yesterday that the accused has continued with his claims that he is not presenting a defense case because of the financing issues regarding his defense and his ultimate disagreement with the registry's procedures which are in place for any payments that need to take place for self-represented accused as well as those represented by counsel. So there are a number of issues that the actual trial chamber needs to resolve before making the decision on the future course of the proceedings. Should the decision on the future course of the proceedings accept that at a certain stage closing arguments are the next step, obviously the closing arguments will take place in accordance with the usual rules, which is both parties are heard, starting with the Office of the Prosecutor and then with the defense. But I just wanted to make clear that we are not yet at the stage where we can definitely say the next thing that will happen are closing arguments. There are other issues to be considered, as discussed yesterday in the administrative hearing.
In terms of Hadžić's lawyer, what does that mean then? If he's not on an approved list, does that mean that he won't be in court today, that somebody else has to be assigned, or that there have to be further checks?
There will be, the duty counsel will be in the courtroom, who is Mr. Jelačić. The duty counsel had been appointed previously, again in accordance with the practice and the rules of the tribunal, because upon the arrival of an accused in the courtroom, a certain time is needed for him in order to decide who he wants to present him, who his lead counsel will be, and who the rest of the defense team he wishes to appoint is. Until that permanent counsel is appointed, they need to be represented by duty counsel. So the duty counsel will be in the courtroom today. The fact that the counsel that he has requested to be permanent is not on the list does not mean that he is not able to be admitted to the list. It just means that he has not already been vetted and practiced before the tribunal.
Okay.
So there are certain issues that need to be addressed by the registrar, and checks in terms of the qualification and the experience of the counsel that he wishes to appoint. And once that has been done, and if he fulfills all the conditions required by the rules, he will be admitted to the list and then appointed as permanent counsel.
So where did Hadžić find him? Where did he come from?
Well, I'm not able to disclose at this stage because the members of the team he wants to appoint have not been publicly named yet in the filings. But should he be appointed, obviously the name will become public. Any other questions?
On Mladić's health, last week there were some concerns, and I know you can't talk specifically about his health, but are you confident that he's able to appear and is fit to appear tomorrow?
Well, again, regarding last week's speculations and what we can now definitely call inaccurate reports that Mladić had been transferred to the civilian hospital called Brnovo here in The Hague. As I said, that is absolutely inaccurate. He had not been transferred, and he had not left the complex in the Scheveningen. Again, it doesn't mean that our detainees are unable to receive medical care and treatment if required within the detention unit and the wider prison system in the Scheveningen. I will not be able to disclose whether Mladić received any treatment or not, but I can only repeat that he, like any other accused, is receiving best possible care, and if any treatment is needed, he is receiving that treatment too. We don't have any information or reasons for concern about his health status, which would make us worry about his ability to participate in a trial. Yeah. If that's it for the questions from the Hague, we have received a question from the journalist from World Policy Journal, who has asked about the work of the ICTY in terms of its cooperation with the local judiciary in the region, and how This cooperation is ongoing, and if it is, can be deemed a success or failure in terms of the local judiciaries in Serbia, Croatia and Bosnia especially, and their adjudication of war crimes trials. So I would like to respond to that question by saying that this is the training and the capacity building of the local practitioners in the region has always been an important aspect of the tribunal's work and indeed its mandate. At the early stages of our work, it was the outreach program that had been the driving force for facilitating the meetings and sharing of the experience between ICTY and their counterparts in the region. In the past 10 years, the ICTY staff has trained local judges, prosecutors, court staff, police officers and other state officials on a variety of topics, including those pertaining to international humanitarian criminal law and its application, as well as witness protection and witness support, investigative techniques, as well as case management. And since July 2010, the Tribunal has been actively involved in a larger EU-funded war crimes justice project and activities which have included a variety of training events, such as the use of analytical tools as well as peer-to-peer meetings between ICTY's judges, prosecutors and other legal professionals. The project has received a lot of positive feedback from the local judiciaries in the region, and their reliance on the ICTY procedures and developed practices and usage of ICTY tools is our greatest indicator of success so far. And with that, we will close today's press briefing. Thank you very much, and we'll see you next week.